Hello and welcome to the Rogers Brief for March 22nd, 2025. I'm Adam Rogers. Thank you for watching and thank you for listening. I'm going to cover three stories today in the Rogers Brief. I'm going to talk a little bit about a visit that the National Judicial Institute had to Nova Scotia, specifically to Wagmatcook this week, in which I participated. And then I'm going to talk about the Chignecto Isthmus settlement and what I think is the result of the Court of Appeal hearing, which took place last week, which was a live broadcast, webcast by the Court of Appeal. And then just a couple of comments on the blind trust question that seems to be surfacing a little bit in federal politics with the new Prime Minister. So I'll talk a little bit about that at the end. Some other cases that I was watching in Nova Scotia this week, a couple involving teachers. One, the teacher up in Tatamagouche that pled guilty to sexual interference with a young boy in the school. She was sentenced this week. There's another trial on in Eastern Passage, well, the trials in Dartmouth involving a teacher there. We'll maybe cover some of that next week or next episode. May also talk about them with Paul Palango tomorrow night. We're still doing these Dispersing the Fog podcasts, so that's Paul Palango and I hoping to secure a guest for tomorrow's show with some special insights, so stay tuned for that. All right, so the National Judicial Institute, what is that? This is the organization that provides education to judges across the country, and judges at all levels, the provincial court right up to the Supreme Court of Canada, courts of appeal, superior courts at all levels throughout the country. And so they were in Nova Scotia in Wagmatcook to observe and have some discussions about the court there. The court in Wagmatcook is a different setup. It's a circular court. It's not it doesn't have the elevated dais for the judge. Everybody's at the same level. But it also, beyond that, is it does have trials, it has bail hearings, but it also has a healing to wellness program, which they do every month. People with addictions issues, mental health issues that are requiring ongoing treatment. And it's also a Gladue court for Indigenous accused and offenders to be sentenced, taking into account the historical factors that would be described, illuminated in Gladue reports. These reports are to provide, the judge with some insight into the circumstances of the offender. And in the case of Indigenous offenders, those circumstances often will involve a history of family trauma, residential schools, day school issues, and poverty, other considerations that are relevant to sentencing, relevant to determining the level of responsibility. So the National Judicial Institute was there because they want to learn what is happening in Wagmatcook. It's unique. There are other Gladue courts that do just the sentencing part of it. They don't do the trial, bail matters, healing to wellness aspects of it. So it is a unique court within Canada, and so these judges want to see if there are lessons from it that they can take across the country, and I believe there are, and I know they do too. After spending 2 days with them, I know they were quite impressed by what was taking place. So on the Wednesday, there was a group discussion. This was filmed for the benefit of the National Judicial Institute. There were elders present. Elders, by the way, provide recommendations on sentencing to the court on each sentencing that's done in a Gladue format. There's a wellness team, which involves probation officers, counselors, other court workers. There's translators, interpreters from the Mi'kmaq language to make sure that aspect of things is addressed, and so that people coming before the court understand what's taking place. There were two chiefs, Chief Norman Bernard from Wagmatcook, former chief of Wakaba Rod Gugu, who were involved in the introduction of the court almost 10 years ago now, 2016 I think it started. There was smudging and lessons from Buddy Young and Tuma Young, There was a youth drumming group, the White Bear drumming group that did the honor song, performed that for everybody. And so, like I say, there was a day of discussion filmed, and then the Thursday, it was an actual court day, and there were many matters before the court. I had the bulk of the docket that day representing legal aid, and did some sentencing, some applications, addressed some other matters. And a lot of the time, these wellness individuals going through the wellness program, they'll come to court every month and give the judge an update on how things are going. The service providers will give an update, so it's really a wraparound service in a way, and has tremendous benefits to those going through it, compared to the regular court system where somebody comes in, they get sentenced, and that's it. It's an isolated incident, and they may learn a lesson, they may not, they may be resentful, they may not, they may, you just don't know what you're accomplishing in some cases. Whereas with the wellness court, there's an ongoing observation of the person, and you can see the growth and the improvement over time. So the court is also unique in this way. It's not just in service to the Indigenous population. It is also a court for non-Indigenous, because it serves Victoria County. So that includes Badek, up into Ingonish. And so there's non-Indigenous offenders coming or accused coming before the court as well, who also get the benefit of this approach. And so that's interesting too. And so I think the NJI was thinking, well, this is something that could be really applied, not even just in Indigenous circumstances, but other communities as well. So keep an eye out for that. There'll be some educational programs coming, and when that happens, we'll certainly, if it's available for the public to see, I'll talk about that when it's unveiled. They said this was okay. So the NJI was thinking, probably within 8 months to a year that they would have a new training program developed around this. All right, so that was the National Judicial Institute visit to Wagmatcook. Next thing I want to talk about is the Chignecto Isthmus. All right, so the news this week was that the federal governments of Nova Scotia and New Brunswick reached an agreement to fund the repairs, bolstering of what they call the protective infrastructure, the dike system that protects the Trans-Canada Highway, CN rail line, electric and fiber optic cables between New Brunswick and Nova Scotia. The Chignecto Isthmus is a very low-lying area. If left unprotected, and I think there's 35 kilometers or miles, I guess it's kilometers, of infrastructure of protective dike system in that area. If that was not there, and certainly if it wasn't there or improved into the future, there's a risk that Nova Scotia really could become an island. I mean, that's a very low-lying area. If you see some of the video particularly from the rail line, I mean, it's right next to the water, and it's certainly at risk. Okay, so what's the issue? The issue is ongoing, is who pays for the repairs, for the improvement of what they call the protective infrastructure. Is it the provinces of New Brunswick and Nova Scotia? Is it the federal government? Is it some combination thereof? Well, the federal government for a few years now has been offering to pay for half of the project. And now the price tag of the project, which was revealed this week, is $650 million. Who knows if that's accurate? This is over 10 years, so a lot of things can happen, price escalations and such. But it was announced this week. Okay, so previously the provinces have said, no, we are not accepting that money, because the money was being promised on a commitment of, well, you pay for your share and we'll pay for this much. Province says, no, it's federal responsibility entirely, and the federal government should pay the entire bill, including any escalating costs. Well, what's the basis for that? The basis is the Constitution of Canada, which divides responsibilities between provinces and the federal government. The provincial, okay, so the way it works is if it's listed under Section 92 of the Constitution, it is within the realm of the provinces. So healthcare, education, you know, well, and local works. Local works is number 10 in the Section 92 list. Local works and undertakings, with the exception of those things that go between provinces. So there we go. Okay, so you have, you know, your fiber optic cable, you've got rail lines, you've got these transportation links that transport goods, transport people between provinces. So, okay, well, there you go then. It's federal, right? Well, not so clear yet, because in this case, it's not the roads themselves, the rail lines themselves, in a sense. It is the protective infrastructure around them that allows those pieces of infrastructure to be in place. So the federal government would argue, and I think has been arguing, that that's a shared responsibility, most likely. Okay, so there was the impasse. Both sides say, well, the provinces say it's a completely federal responsibility. The federal government says it's a shared responsibility. What does the province do? Province of Nova Scotia in 2023 makes a reference to the Nova Scotia Court of Appeal. Now, this is something that the provincial governments can do to their own courts of appeal. The federal government can do to the Supreme Court of Canada. It's a legal question of significance. There's no case necessarily that needs to be brought forward. It can just be a reference. Important matters of public policy or legal questions that need to be answered. So the Nova Scotia government brought this to the Nova Scotia Court of Appeal, and this is a question of who has responsibility for those pieces of infrastructure, for the protective infrastructure around it, that being the dike system. Just got to court during March break, the Tuesday of March break, and it was webcast by the Court of Appeal, which is very helpful. I got a chance to watch the first bit of it live, and then came back to watch the provincial arguments after the fact. So there was Court of Appeal, 3-member bench with Chief Justice Wood, Justice Farrar, and Justice Derrick sitting. It was Laurie Ward, counsel for the federal government, who would be familiar to those who watched the Mass Casualty Commission, also the Desmond Inquiry. She was representing the federal government at both of those. For the province, it was Jeremy Smith and Daniel Boyle, both of whom made different parts of the province's arguments. I watched this. Okay, so think of the timing of this. You have an impasse. So what led to was it a capitulation by the province? Was it something else? Well, think of the timing. We have two things that are relevant. One is this Court of Appeal hearing. And it wasn't even an appeal hearing on the substance of the issue itself. It was a sort of preliminary question as to whether the question raised by the province, who has responsibility for the protective infrastructure, was specific enough for the Court of Appeal to answer. So the federal government suggested there was doubt as to what protective infrastructure means, the extent to which there was, where is the isthmus, where are the boundaries of it, and other sort of uncertainties. Questions as to, okay, well, is it the road or is it the traffic over the road? Because the province owns the road, the traffic over it is the interprovincial trade. So some uncertainties there, and that's what this preliminary hearing was set to answer. So then the court didn't make a decision on that. But anybody watching the hearing would, if you didn't know much about the issue beforehand and you just listen to the two arguments, listen to the questions from the bench, one would certainly have thought the federal government came out ahead during the hearing. The province, the lawyers for the province were on their back foot, getting pushed with tough questions from the bench. The basic thrust of the questions was this. Okay, so the province is basically, there's no legislation. There's no legislation to analyze, so there's a lack of clarity there, because what are we really answering here? If there's no legislation, there's no case. Okay, it's a pretty broad question as to who has responsibility. Then the fundamental difficulty, though, is the real question that the province wants answered is who pays for the repairs and the bolstering of the infrastructure. But both parties said in their introductory portions of their remarks that that was not the question that the government was asking the court to answer. That the court was not being asked to answer the question of who should pay for these, infrastructure improvements. But that is the question, and it seemed like a really difficult, really contradictory stance on the part of the province to say, on the one hand, we need you to answer this question as to who is responsible, but not answer the question of who pays for. Well, that's the same question. I don't understand why the province conceded that, took that stance or conceded that stance. It's not clear which one they did. That it was not a question of who pays for this. That is the only question. And so, in trying to answer some of the questions from the panel, from the Court of Appeal Justices, Mr. Smith and Mr. Boyle were really, kind of twisting themselves around a little bit to say, well, no, we just need you to say who's responsible, and then anything that comes from that is going to be a political question. Well, I can tell you, and the judges are certainly alive to this, that whatever they decide is going to be then taken by the political actors involved to say, well, here's the decision from the Court of Appeal that says who is responsible, and if the decision is the federal government is fully responsible for that infrastructure, you can have 100% certainty that that is what the province is going to say in their next discussion about funding. The court says you're responsible, therefore you also are responsible to pay. Okay. So two things happen on the timing. One is we have a federal election that's probably going to be called tomorrow. So the federal government and Dominic LeBlanc, the minister from New Brunswick, interprovincial trade minister, I think, at this point as well, he certainly wants that announcement to be made and get that money committed and have that in place before an election is called, because afterwards he wouldn't be able to make that financial commitment. So he wants that in place before the election so he can campaign on it. But I also think this court hearing, which did not go well, I would say, for the provinces, has motivated the provinces to say, well, now we are ready to put up our share, because now it's the federal government's paying 50%, New Brunswick's paying 25%, Nova Scotia's paying 25%. So it's a 50-50 split. Shared responsibility, as anybody who had thought about that legal question would have said. It's shared responsibility. Nova Scotia has legislation discussing the dike system in the Isthmus. It's a shared responsibility. It seems like just a question of who pays what and the percentages and that sort of thing. So I know when the province announced that they were going to, put up 25% of the cost, they said they were getting on board because of the tariffs from the United States and the importance of interprovincial commerce. So, okay, yes, making it about a current issue, which is politically advantageous to the government. I think the real explanation here is the realization that the Court of Appeal was not going to buy the arguments that it was 100% federal responsibility, and therefore they made the best of a situation and are going to accept the $325 million from the federal government and more as costs escalate over time. Okay, so that's what I wanted to say about the Chignecto Isthmus decision. Well, there is the substantive portion of the arguments are going to be made in May before the Court of Appeal. Not sure if we'll get a decision on this preliminary question or if the court will just hear the appeal, hear the main part of the appeal, while I guess withholding their decision on the initial question. I mean, they could, and this is often the case with court decisions, they may decide the issue on a preliminary hearing, or they may just amend the question or clarify the question themselves and then answer it. They may sometimes also say, well, all right, here's our decision on the initial question, and that means the federal government or the provincial government wins. However, we will still answer the secondary part of the question anyway, just in case it goes to a higher level and the first part's overturned or something like that. So there's lots of things that'll happen, and I'm sure they will want to provide a fulsome answer to a reference question. Okay, that's enough for the Chignecto Isthmus. Last thing I want to talk about is just this question of the blind trust with the new Prime Minister, and he is a wealthy individual, we all seem to think, at least, and he's worked in the private sector as well as for the Bank of Canada, the Bank of England, worked for Brookfield Asset Management, worked for other private investment firms before going into the Bank of Canada work and Department of Finance. So okay, he's well off, he has investments. What does that mean? Now that he's the Prime Minister, many decisions that he makes or is involved with making are going to potentially affect his asset portfolio. So, okay, then what's the issue there? Well, if he has, $1 million worth of stock in Tesla and makes decisions that affect the Tesla stock, well, or bans Teslas from Canada or allows them to go into Canada, well, that's going to affect his portfolio. So they put them in a blind trust. So a blind trust means that there would be a trustee appointed, and all of those financial assets, other than his personal home, would be controlled by somebody else. And Prime Minister Carney would not have the ability to decide what happens to those. The trustee could sell certain assets and could transfer things, could make changes to the asset portfolio, and would not be permitted to tell the Prime Minister what's taken place. The key to all of this, and any time a trustee is appointed, the trustee must act in the best interests of the owner of the assets. You see this often in cases where somebody's getting dementia or Alzheimer's and their assets need to be managed by somebody. Well, you manage those to increase their value and accord with the wishes and values of the person who owns them. In this case, the Prime Minister, the trustee for the Prime Minister would have to just make sure that they were getting good value for their assets. Could sell things, could transfer or switch things around to certain different asset portfolio or different asset classes, from stocks to bonds, whatever they thought was in the best interests of the portfolio. Okay, so over time, certainly the potential is there that the Prime Minister wouldn't know what was in there, and so decisions that he was making or a part of making, he wouldn't know whether they were affecting. But now, right now, of course, he knows what's in the asset mix. There's shares of Brookfield, of his former company. There's, whatever he owns, he knows. So decisions that he makes as Prime Minister could potentially affect his assets. It is the responsibility of the Prime Minister himself to know when those decisions might affect his asset portfolio and recuse himself. And that happens with politicians at all levels, municipal right up to the Prime Minister, that have decision-making authority over financial matters. So what's the alternative? The alternative would be for the Prime Minister to disclose to the public all of the assets that he owns. Well, what's the problem with that? One problem is, big picture, it would mean people who have accomplished some things and have some assets are not going to want to run for public office, because the theory goes they are not going to want to disclose what they have. Okay. The other option, and this is one that I understand is part of the office of the Ethics Commissioner, is that there's a screen set up, and so somebody would know what is in the asset portfolio, and if there are decisions to be made dealing with any of any company, any contract that's going to go to Brookfield, the Prime Minister is not going to be allowed to be involved in those kind of decisions. And there would be a screen set up to make sure that that didn't happen, that information regarding a decision of that nature wouldn't be included in any briefing material that the Prime Minister received, that sort of thing. That's how those screens will work. And like I say, but there's also just a simple matter of trusting that the Prime Minister is not in there to just try to enrich himself, but rather to serve the country, and would declare conflicts where they are apparent. So it's not a perfect answer. It involves some trust. It involves a blind trust. Over time, certainly it becomes maybe less of an issue initially here, where there's decisions to be made. The Prime Minister would know his asset mix. So it's a little bit disingenuous of him to say, well, it's not an issue at all. Well, just describe the issue in more detail, and don't get so testy in your answers. So anyway, that's just some thoughts on the blind trust question. I think it's maybe an issue of trying to make some, or draw some attention maybe to the fact that the Prime Minister is a wealthy person. Doesn't seem like the kind of person that's just in there to try to enrich himself, maybe contrary to the big guy down south. But anyway, we'll see. We're just getting to know our Prime Minister a little bit, so that all remains to be seen. Anyway, those are thoughts for this week. Come back probably next week if there's more stories to discuss, and certainly tomorrow night, check out at 8:30 p.m. There's a new episode of Dispersing the Fog with Paul Palango, and hopefully a special guest. So watch for that on YouTube, Apple, and Spotify, and we'll be back here as well next week here with more Rogers Brief, and hope to see you then. Thanks for watching, and we'll see you next time.